Okay, so let's talk about a huge collision that's happening right now. In one corner, you've got this incredible, groundbreaking generative AI, tech that can create pretty much anything you can dream up. And in the other corner, you have copyright law, which for centuries has been built to protect human creativity. Today, we're going to unpack that exact collision.
And this is really the question at the heart of everything. When you look at AI, what do you see? Is it like a brilliant student, absorbing the entire library of human knowledge to create something totally new? Or is it more like a high-tech plagiarist, just digitally tracing over the very works it was trained on? As you're about to see, the truth is way more complicated than that.
But hey, before we can even get into the legal drama and the courtrooms, we've got to look under the hood of the machine itself. Because if you don't understand how these AI models actually learn, none of the legal arguments are going to make sense. It's not magic, it's a process, and that process is right at the center of this whole debate.
So how does an AI learn anyway? Well, it all starts with something called tokenization. It basically breaks down, say, a masterpiece painting into its most fundamental bits, pixels, colors, shapes. Then comes the really critical part, pattern recognition. The AI is not memorizing the painting. It's learning the statistical probability that certain brushstrokes tend to follow others. It's learning the rules of that art style. So when you ask it to create something, it's not just pulling a copy from a memory bank. It's using those learned patterns to generate something completely new.
Here's a good way to think about it. An AI isn't a scrapbook, right? It's not just pasting in copyrighted photos it found. It's more like a distillery. It takes in millions of images and boils them all down to extract the pure essence of what makes a cat, or what makes the style of Van Gogh, Van Gogh. And whether that whole distillation process is actually legal, well, that's the multi-billion-dollar question.
Okay, so that's the tech side. Now let's switch gears and look at the other major player in this whole conflict, copyright law. For literally centuries, these rules have been like a shield for creators. The only problem? That shield was designed way before anyone could have possibly imagined something like artificial intelligence.
In India, the Copyright Act basically hands a whole set of keys to the creator. They get the only keys to reproduce their work, to adapt it, to perform it in public, or even just to store it on a computer. It essentially builds a legal fortress around their creation. And now you've got this powerful AI standing right at the front gate.
And this is where we get to the real legal tug-of-war. On one side of the scale, you have copyright infringement. That's using someone's work without their permission. Simple enough. But on the other side, the law makes an exception called fair dealing. It's a crucial little loophole for things like research or criticism. So the big question becomes, is training an AI a form of research, or is it just massive, unauthorized copying?
All right, I need you to lean in for this next part, because what we're about to cover, it might just be the single most important legal concept in this entire debate. This one idea could be the key that unlocks the whole puzzle. It's called the idea-expression dichotomy. Now that sounds complicated, but the concept is actually pretty simple. Copyright law protects the way an idea is expressed. The specific words you use in a novel, the exact brushstrokes in a painting. But it doesn't protect the underlying idea or the facts. So you can copyright your book about a boy wizard, but you can't copyright the general idea of a boy wizard.
And look, this isn't just some dusty legal theory. The Supreme Court of India has backed this up. The whole point of copyright isn't to lock knowledge away in private vaults. It's to encourage people to share their unique expressions of ideas. This is absolutely foundational because AI developers are going to argue they're only learning from the general knowledge, not stealing the specific expression.
Okay, so with that idea versus expression concept in our back pocket, we can finally dissect the two different phases of an AI's life. There's the training phase, and then there's the output phase. What an AI does to learn and what it does to create are two very different things in the eyes of the law, and we have to look at them separately.
So here's the first big legal landmine. For an AI to learn from, say, 1 billion images, it has to make these temporary, intermediate copies of that data inside its own system. Now, these copies might only exist for a fraction of a second, and no human ever sees them. But does that purely technical act, by itself, count as mass copyright infringement?
You see, you've really got two different battlegrounds here. During the training stage, the main defense isn't about the final image. It's about the purpose of all that copying. The argument is that it's transformative, that the data is being used for a completely new purpose, which is just to learn. But then, once you get to the output stage, the whole argument shifts. Now, it's all about the result. Is the AI's creation a genuinely original work, or is it just a substantial copy of something it was trained on?
So, what about that final image or that final piece of text the AI spits out? Well, the legal test here is substantial similarity. Basically, would an ordinary person, not a lawyer, just a regular person, look at the AI's creation and the original work and think one is a copy of the other? So if an AI generates an image of a superhero that looks almost exactly like Superman, that's going to be a problem. But if it generates a totally new superhero, just in a similar style, that's probably okay.
But let's play this out. Let's say the worst-case scenario happens, and an AI does spit out a direct copy of a protected work. So, who's on the hook? Does the blame stop with the person who typed in the prompt, or does it go all the way back to the company that built the AI model in the first place?
You know, the law is really looking at a whole chain of responsibility here. On one end, you have the developers. If they build an AI with zero safeguards and it's constantly just spitting out copyrighted stuff, they could be in big trouble. But on the other end, you've got the user. If a user deliberately tries to trick the AI to bypass its safety filters, to force it to copy something illegal, well, then the liability could easily shift right onto them.
So when you step back from it all, you can see we're walking this incredible legal tightrope. If you lean too far one way, you risk undermining the very creators whose work is the foundation of our entire culture. But if you lean too far the other way, you could end up stifling one of the most powerful technological revolutions in human history.
And so, this is where we're left. Generative AI is changing the fundamental meaning of creativity. And our laws, which were written for a totally different world, are now racing to keep up. The challenge ahead isn't about picking sides between artists and coders. It's about designing a future where both can thrive.